Trenton Garmon here. An American Bar Association article is the subject of this brief video. This is a notice video for the general public and specifically for the ABA, mainly because it's very unfortunate. It's not real clear exactly how this happened, but it's obviously an extreme misrepresentation. Here's the article on the ABA website. If this was not my professional work product, I may not be so concerned. But given it is my professional work product, I've taken on the task of filing suit after providing notice if this is not mitigated. Article says Roy Moore's lawyer, and you can see it says a former client of mine, particularly I believe it's opening up that way because that's what they intend to do, is to take a position with regards to him and the attack. Threatens website with, now this is what their terminology is, utterly incoherent, which we'll look up and see what that means. But come on down here and you can look and read with me. This is what was taken supposedly out of the letter that was written. And there's no part of that letter that's incoherent whatsoever. And here's a letter shared over its 3 pages, 4 including the signature and the closing. But I want to show you this. Do you know is what they have put in their article. But if you look, this do note, those are 2 totally different words. So they've added do you know as compared to do note, and then claim that the letter, they take 1 sentence out of the letter and change 2 words and claim that the letter is incoherent. Now that is a very, very malicious attack. And the reason it's malicious is because this letter went on to get my client a verdict in its principles. There was other evidence that was built on a verdict of $9 million down in Louisiana. So the American Bar Association's journal has taken in from a typed up article, typed up letter, written an article based on another article that misquotes a letter. And hopefully they're going to come in and correct that. But to claim that someone who's representing the Chief Justice at the time's work product is incoherent and using 2 sentences, the first one's coherent, the second one is coherent if you read it as it was written, and changing 2 words makes it incoherent, but that's not the words that were written. So here's the actual letter that was written, and this was again on behalf of a client way back in 2017. I had not seen before today, yesterday, that article because I just hadn't really researched and looked for it. But that's it on the ABA website. There's the HTTPS. There's the domain for it where it's posted. And then here's the actual letter that it purports to be summarizing as utterly incoherent. And as a professional, there is such thing as a standard of care. Now, unfortunate for Debra Weiss, she doesn't have the practice experience, I believe that's her name, to appreciate that. But a professional minimum standard of care, if that's met, then saying that it's utterly incoherent would mean that that's defamation. So the minimums, if there is a situation that needs notice, is that the person of a defamation or some misrepresentation, the person be provided the notice, they receive it, the notice be sufficient in its detail of what you're disputing, and offer up what is an alternative to the misrepresentation or the correction needs to be made, which you believe the truth is, then the opportunity and ability for them to make some kind of amends or mitigation to that defamation. So the American Bar Association typically is good on a lot of issues, mainly trial by jury. It's been very protective over and immigration. But this particular lady is now subjecting our bar association as American trial lawyers by taking a sentence. I don't dispute this sentence being in the letter, and it's coherent. I don't dispute this sentence being in the letter, except for these 2 words right here. And that makes a significant difference to change someone's work product and then blast it on the ABA's website and claim that there's some type of incoherency because of it. Because here's the actual letter. Please allow the service that our firm represents to be retained by the Foundation for Moral Law. It's very clear. President Kayla Moore and Chief Justice Roy Moore. Also, to make note, about 4 or 5 days prior to this, I originally went on television representing just the foundation and Kayla, not the Chief Justice. So this is after the fact. Then it lays out just very clearly what we're requesting of them to do. Alerted them to duties, notices here and provided to the Alabama Media Group. It's very evident. There's nothing incoherent about that. This letter is provided in anticipation of our firm preparing and filing a lawsuit. Very evident. They can read it themselves. That's what it says. Your clients engaging in false reports and or careless reporting is what it is. They can say that it was false based on a prior report that was made by somebody else that was false. That's correct. Or it was careless because they didn't check up on the prior report. And adverse to my client, claiming that a fifth woman has accused this client of sexual misconduct. Well, the fifth woman said that he was being awkward. Either way, I don't defend people who've done things that admit they've done it and think there's no damage to it. People deny it, and the facts and circumstances give conditions to believe that it's reasonable to have a denial. I'll defend them in their denial, not defending the alleged underlying conduct. And that's what occurred here. Clearly coherent letter, an accurate reporting that travel expenses and accommodation of clients to include a private jet was used. That was part of what was claimed. That's clearly coherent, rebutting something. Your client's an outlet that it's being careless and malicious, very clear. So went through and makes, I believe the letter does, very obvious arguments on behalf of my client that can't be disputed because they're in black and white. No other portion of the letter was attacked as incoherent or unable to be distinguished or unintelligible, because the letter is actually a damn near perfect letter, but for commas and quotations being considered to be needed one place or another, or run-ons. And I'm going to address that because when you write a legal correspondence, which again, people like Debra Weiss who've never actually practiced law. So these are keyboard lawyers pretending to be practitioners. You know, they don't appreciate this, like here, for instance, the Code of Alabama. If you look at this structure, sentence number 4 and section 111, signature or subscription, you see there's a sentence with a comma, there's another sentence with a comma, and there's another sentence connected with an and. Because these are legal writings. You're wanting to make sure you don't have minimum requisite elements that may be 3 parts divided into 3 sentences, or 3 parts divided into 2 sentences plus 1. So the truth of it is Debra Weiss has no idea what she's even talking about when she writes an article like this and relies on above the law, because this is what her article says right here. These 2 incoherent sections, this is not incoherent, very clear. This is not incoherent at all, but for these 2 words. So they go and they change, please also note, so that particular sentence is down here at the bottom. And it's distinguishing a difference in, thus do clearly note the number of accusers, a distinguishment between he was being awkward at the mall versus 2 said that he touched him or did something inappropriate. All of which I say would be wrong and inappropriate. But if someone's doing something awkward, you may be imputing intentions. But either way, when it comes to the defense through the letter, and I believe in traditional marriage, one man, one woman, arranged by free will, choose who you will, get the approval of the parents or the people that are in charge of the community that you're going to be doing life with. So this letter made it very evident the position that we took. It obviously was successful because the client eventually was able to prevail in response to much of this attack and correcting the information. And so legally put on notice and then putting on notice the American Bar Association Journal that they are reporting that I wrote this sentence, and I did not write that sentence. In fact, the sentence I wrote is in my letter, and they need to correct that. The letter is not a professional work product failure. The letter was a professional work product success. So to call it utterly incoherent is absolutely asinine and not in line with the de facto reality. So I do request that rather than attack my work product, you take the work product for what it is, rather than misrepresent that there's some kind of run-ons. Take the genre of the law and evaluate what the genre of the law says. Those elements are being considered on notice. This is what we're saying is wrong. This is how you fix it. This time period, you got to get it done by then. So anyway, that's the plan for the defamation lawsuit against American Bar Association Journal. The request is that they remedy that misrepresentation and also do it quickly. Otherwise, suit will be filed. And it is being drafted. Here's the suit right here. Trenton Garmon versus American Bar Association. And I would not be doing that if it was not my own professional association, but I have spent 25 years, there's a lawsuit there, studying the law, being a student of the law. And so I'm not going to allow someone to attack my work product inappropriately and fraudulently. It's inappropriate because it is a minimum sufficient standard of care legal product, and it's misrepresentative because it misquotes me. That's not at all what was written. Peace be with you.